everybody. Thank you very much for taking the time to listen to the GDPR Consulting presentation. This presentation is planned to give you an overview of the GDPR Consulting services. My name is Thomas Goddard. I'm a Prince Consultant. There's 3 people in the team. I'd now like to hand over to Ram.
Ram Kundanani, Principal GDPR Consultant, and
Rizwan Gauri.
Thank you very much indeed. If we can move to slide 2. So what are we going to cover today? Well, there's 6 key areas. The presentation is going to take approximately 20 minutes. There's about 15 slides. We'll give an introduction to GDPR, 5 pillars of GDPR. We'll be covering the compliant process which we'll be following, which is the ICO Information Commissioners and Officers, and the 12 principles, implementation process, how we will support you, and contact details and next steps. If we can move to slide 3, please. So as most of you will probably know, the enforcement effect with GDPR takes effect on the 25th of May. Fines of 4% of annual global turnover, breach notification within 72 hours of mandatory data protection officers, privacy by design, right to access and portability, explicit and retraceable consent, right to be forgotten. Previously, fines were limited to the size and impact. GDPR fines will allow to both controllers and processors. GDPR will apply to all companies processing data of data subjects residing in the EU, regardless of the company's location. Must be provided in all intangible and easy accessible form using clear and plain language. It must be easy to withdraw consent as it will be given. 72 hours now mandatory the breaches, which are likely to result in risks for the rights and freedoms of individuals, are reported within 24 hours of first having become aware of the breach. Now, legal requirement for the inclusion of data protection from the onset of the designing of systems, rather than the retrospective addition. Pointed in certain cases, public authorities, when monitoring of data subjects on large scale and when processing special categories of data, to facilitate the need for a company to demonstrate their compliance to the GDPR and compensate for GDPR no longer requiring bureaucratic submission of notifications, registration of data processing activities or transfers based on model contract clauses. Entitle the data subject to have the data controller erase his or her personal data, cease further dissemination of data, and potential that third parties hold processing of data. Data subjects can request confirmation as to whether or not personal data concerning them is being processed, whether and for what purpose. Further, the control cell provide a copy of personal data free of charge in the electronic format, GDPR. So we move on to slide 4. The diagram shows the 5 stages of GDPR: know your personal data, collect, reconcile, take control, data protection, self-service curation and certification, data access, portability. The GDPR brings about several major challenges that businesses will need to address before the enforcement deadline. The most daunting of these challenges surrounding data governance, organizational structure, cross-team collaboration include: 1. Determining whether personal data is stored across multiple different potential silo data sources. 2. Aligned everyone across the organization, including IT, marketing, customer services, data teams, on new policies and execution of changes. 3. Putting processes in place to accommodate requests from data subjects and ensure all teams can execute on processes in a timely manner. 4. Ensure proper data governance, security and monitoring are in place in case of audit. 5. Implementing agile solutions that keep your operations flexible and easy adaptable to change. Now I'd like to hand back to Ram for slide 5.
Thank you, Thomas. I will continue with the 12-step principles of ICO. Many of GDPR's main concepts and principles are much the same as those in the current Data Protection Act. So if you are complying properly with the current law, then most of your approach to compliance will remain valid under the GDPR and can be a starting point to build from. However, there are new elements and significant enhancements, so you will have to do some things for the first time and some things differently. It is important to use this checklist and other ICO resources to work out the main differences between the current law and the GDPR. The ICO is producing new guidance and other tools to assist you, as well as contributing to guidance that the Article 20 Working Party is producing at the European level. These are all available via the ICO's overview of the General Data Protection Regulation document. The ICO is also working closely with trade associations and bodies representing various sectors. You should also work closely with these bodies to share knowledge about implementation in your sector. It is essential to plan your approach to GDPR compliance now and to gain buy-in from key people in your organization. You may need, for example, to put new procedures in place to deal with the GDPR's new transparency and individuals' rights provisions. In a large or complex business, this could have significant budgetary, IT, personal, governance, and communications implications. The GDPR places greater emphasis on the documentation that data controllers must keep to demonstrate their accountability. Compliance with all the areas listed in this document will require organizations to review their approach to governance and how they manage data protection as corporate issue. One aspect of this might be to review the contracts and the other arrangements you have in place when sharing data with other organizations. Some parts of the GDPR will have more of an impact on some organizations than on others. For example, the provision relating to profiling or children's data. So it would be useful to map out which parts of the GDPR will have the greatest impact on your business model and give those areas the prominence in your planning process. Let's look at the principles in detail. Awareness. You should make sure that decision makers and key people in your organization are aware that the law is changing to GDPR. They need to appreciate the impact this is likely to have and identify areas that could cause compliance problems under the GDPR. It would be useful to start by looking at your organization's risk register, if you have one. Implementing the GDPR could have significant resource implications, especially for larger and more complex organizations. You may find compliance difficult if you leave your preparations until the last minute. Information you hold, you should document what personal data you hold, where it came from, and who you share it with. You may need to organize an information audit across the organization or within the particular business areas. The GDPR requires you to maintain records of your processing activities. It updates rights for a network world. For example, if you have inaccurate personal data and have shared this with another organization, you will have to tell the other organization about the inaccuracy so it can correct its own records. You won't be able to do this unless you know what personal data you hold, where it came from, and who you share it with. You should document this. Doing this will also help you to comply with the GDPR accountability principle, which requires organizations to be able to show how they comply with data protection principles, for example, by having effective policies and procedures in place. Now I will talk about communication privacy information policy and principle of ICO. You should review your current privacy notices and put a plan in place for making any necessary changes in time for GDPR implementation. When you collect personal data, you currently have to give people certain information such as your identity and how you intend to use their information. This is usually done through a privacy notice. Under the GDPR, there are some additional things you will have to tell people. For example, you need to explain your lawful basis for processing the data, your data retention periods, and that individuals have right to preparing for the General Data Protection Act. Uh, 12 principles to take now complain to the ICO if they think there is problem with the way you are handling their data. The GDPR requires the information to be provided in concise, easy to understand and clear language. The ICO's privacy notices code of practice reflects the new requirements of the GDPR. Next principle is individuals' rights. You should uh, check your procedures to ensure they cover all the rights individuals have, including how you would delete personal data or provide data electronically and in a commonly used format. The GDPR includes the following rights for individuals: the right to be informed, the right of access, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, and the right not to be subject to automated decision making, including profile. On the whole, the rights individuals will enjoy under the GDPR are the same as those under the DPA, that is Data Protection Act of 1998, but with some significant enhancements. If you are geared up to give individuals their rights now, then the transition to the GDPR should be relatively easy. This is a good time to check your procedures and to work out how you would react if someone asks to have their personal data deleted. For example, uh, would your systems help you to locate and delete the data? Who will make the decisions about deletion? The right to data portability is new. It only applies to personal data an individual has provided to a controller, where the processing is based on the individual's consent or for the performance of a contract, and when processing is carried out by automated means. You should consider other whether you should consider whether you need to revise your procedures and make changes. Uh, you will need to provide the personal data in a structured, commonly used and machine readable form, and provide the preparing for the General Data Protection Regulation. Next principle is subject access request. You should update your procedures and plan how you will handle a request to take account of the new principles. In most cases, you will not be able to charge for complying with a request. You will have a month to comply rather than the current 40 days. You can refuse or charge for requests that are manifested unfounded or excessive. If you refuse a request, you must tell the individual why and that they have the right to complain to the supervisory authority and to a judiciary body. Uh, you must do this without undue delay and at the latest within a 1 month. If your organization handles a large number of access requests, consider the logical implications of having to deal with requests for more quickly. You could consider whether it is feasible or desirable to develop systems that allow individuals to access their information easily online. Next principle is lawful basis for processing personal data. You should identify the lawful basis for your processing activity in the GDPR, document it and update your privacy notice to explain it. Many organizations will not have thought about their lawful basis for processing personal data. Under the current law, this does not have any practical implications. However, this will be different under the GDPR because some individuals' rights will be modified depending on sorry, depending on your lawful basis for processing their personal data. The most obvious example is that people will have a stronger right to have their data deleted where you use consent as your lawful basis for processing. You will have to explain your lawful basis for processing personal data in your privacy notice and when you answer a subject access request. The lawful basis in the GDPR are broadly the same as the conditions for processing in the Data Protection Act of 1998. It should be possible to review the types of processing activities you carry out and to identify your lawful basis for doing so. You should document your lawful basis in order to preparing for the GDPR 12 steps which will help you comply with GDPR's accountability requirements. I will now pass over to Thomas to give you more information about GDPR.
Thank you very much indeed, Ram. So the next two ICO principles I'd like to talk about on the next slide is consent and children. So number 7, consent. You should review how you seek, record and manage consent and whether you need to make any changes. Refresh existing consents now if you don't need meet the GDPR standard. You should read the detailed guidance and ICO has published on consent under GDPR and use our consent checklists to review your practices. Consent must be freely given, specific, informed and unambiguous. There must be a positive opt-in. Consent cannot be inferred from silence, tick-boxed or inactivity. It must also be separate from other terms and conditions, and you will need to have simple ways for people to withdraw consent. Public authorities and employers will need to take particular care. Consent has to be verified and individuals generally have more rights where you rely on consent to process their data. You are not required to automatically repaper or refresh all existing DPA consents in preparation for the GDPR. But if you rely on individuals' consent to process their data, make sure it will meet the GDPR standard on being specific, granular, clear, predominant, opt-in, properly documented and easily withdrawn. If not, alter your consent mechanisms and seek fresh GDPR compliant consent or find an alternative consent. So moving on to the next principle, 8, children. You should start thinking now about whether you need to put systems into place to verify individuals' ages and to obtain parental guardian consent of any data processing activity. For the first time, GDPR will bring in specific protection for children's personal data, particularly in consent of commercial internet services such as social networking. If your organisation offerings online services, information society services to children and relies on consent to collect information about them, then you'll need a parental or guardian consent in order to process their personal data lawfully. The GDPR sets the age when a child can give their own consent to the processing at 16, although this may be lowered to a minimal age of 13 in the UK. If a child is younger, then you will need to get consent from a person holding parental responsibility. Preparing for the GDPR, the 12 steps now is vitally important. This could have significant implications if your organisation offers online services to children and collects their personal data. Remember that consent has to be verified and that when collecting children's data, your privacy notice must be written in language that children will understand. So let's move on to the next slide and have a look at data breaches and data protection by design and data protection impacts. Data breaches. You should make sure that you have the right procedures in place to detect, report and investigate a personal data breach. Some organisations are already required to notify the ICO and possibly some other bodies when they suffer a personal data breach. The GDPR introduces a duty on all organisations to report certain types of data breach to the ICO and to make some cases to individuals. You only have to notify the ICO of a breach where it is likely to result in risks to the rights and freedoms of individuals. If, for example, it could result in discrimination, damage to reputation, financial loss of confidentiality, or any other significant economic or social disadvantage. Where a breach is likely to result in higher risks to the rights and freedoms of individuals, you also have to notify those concerned directly in most cases. You should put procedures into place to effectively detect, report and investigate a personal data breach. You may wish to access the types of personal data you hold and document where you would be required to notify the ICO or effective individual if a data breach occurs. Large organisations will need to develop policies and procedures for managing data breaches. Failure to report a data breach when required to do so could result in a fine, as well as a fine for the breach itself. So, the next principle, 10, data protection by design and data protection impact assessment. It has also always been good practice to adopt a privacy design approach and to carry out privacy impact assessment, PIA, as part of this. However, the GDPR makes privacy by design an express legal requirement under the term data protection by design and by default. It makes PIAs, referred to as data protection impact assessments, DPIAs, mandatory in certain circumstances. Preparing for the data protection 12-step principles in situations where data processing is likely to result in high risk to individuals. For example, where a new technology has been deployed, where a profile operation is likely to significantly affect individuals, or where there is processing on a large scale and special categories of data. If a DPIA indicates that the data processing is high risk and cannot significantly address those risks, you will be required to consult the ICO and to seek its opinion as to whether processing operational complies with GDPR. You should therefore start to assess the situations where it will be necessary to conduct DPIA, who will do it, who else needs to be involved, will the process be run centrally or locally. You should also familiarise yourself now with the guidance the ICO has produced on PIAs, as well as guidance from the Article 29 Working Party, and work out how to implement them in the organisation. This guidance shows how PIAs can link to other organisation processes such as risk management and project management. So let's move on to the final two steps, data protection officers and 12 international. Data protection officers. You should designate someone to take responsibility for data protection compliance and assesses where this role will sit within your organisation structure, governance arrangements. You should consider whether you are required to formally designate a data protection officer, DPO. You must designate a DPO if you are a public authority exempt from court acting in judicial capacity, an organisation that carries out regular and systematic monitoring of individuals on a large scale, or an organisation that carries out large-scale processing of special categories of data, such as health records or information about criminal convictions. The Article 29 Working Party has produced guidance for organisations on the designation, position and tasks of DPOs. Preparing for the GDPR, the 12-step process will help and secure this process for you. It is most important that someone in your organisation or an external data protection advisor takes proper responsibility for your data protection compliance and has a knowledge support authority to carry out this role effectively. So let's move on to the final stage, international. If your organisation operates in more than one EU member state, you should determine your lead data protection supervisor authority and document this. This authority is the supervisory authority in the state where your main establishment is. Your main establishment is the location where your central administration in the EU is, or else the location where decisions and process and means the processing has taken and implemented. This is only relevant where you carry out cross-border processing, i.e. you have establishments in more than one EU member state, or you have a single establishment in the EU that carries out processing which substantially affects individuals in other EU states. If this applies to your organisation, you should map out where your organisation makes its most significant decisions about its processing activities. This will help to determine your main establishment and therefore your lead supervisory authority. The Article 29 Working Party has produced guidance on identifying a controller, processor, lead supervisory authority. I'd now like to hand back to Ram to take on the next slides.
I will now explain to you about the business process simulation. Sorry. Thank you, Thomas, for handing back to me. I will now explain to you two more very important elements of GDPR compliance, which are the business process evaluation and the legal contracts. While you are working towards the GDPR compliance, you need to focus, the GDPR itself focuses on security and protection of personal data throughout data journey of data subject. Now, in many organizations, this element is lacking because of the very old databases being used, or the silos of data being used by different departments for different purposes. So, as part of GDPR compliance, you need to go for the evaluation of the data journey of the data subject from the point of capture to monitoring to managing. Then, in order to establish data journey and understanding points of potential data leakage, it is important to review your business processes. And as per GDPR, the leakage at 4 different points need to be assessed. One is at the user level, second is at the application level, third is at the database level, and fourth and final either at the data center or at the cloud level. And this needs to be assessed at each of the points, and wherever there is a potential risk for the data leakage, the necessary improvements need to be made. Then an organization may provide business process documentation to be reviewed for GDPR compliance, and GDPR Consultancy can deliver businesses as a service. Now this element is more from our perspective, that if the organization has already done some amount of work for GDPR compliance or has some of the documentation for Data Protection Act 1998 available, then GDPR Consultancy can review that and come out with some solutions to the organization. Next step involved in the business process evaluation is the impartially review the content and submit the report for enhanced security if required. If everything is in place, nothing to be done. The final step is if the organization has business process documents, then it is fine. But if they do not have, then GDPR Consultancy will help the organizations with the expertise of business analyst to create the required business processes and submitting the report for approval before the whole process is implemented. So this everything is around the business process evaluation. The last important element of the GDPR is the legal contracts. Each organization needs to review all their legal contracts where there is an element of data protection for its security and for GDPR compliance. If the organization has its own legal team, they can relook at all the contracts, and if they do not have one, then we at GDPR Consultancy will be more than happy to help seek the advice and the support from the team of solicitors from our panel. I will now take you to the next step, and that is on the implementation side of things. It's very simple, like any other project management. It is plan, discover, analyze, remodel, and implement. These are all the steps that we need to follow through. The first step is have the close alignment with customer stakeholders and the project formulation. So at this stage, it's basically setting the right scope of work for GDPR compliance. Then analysis of GDPR readiness on 3 key areas, which is IT processes and the legal. The next step is assessment of the current state, including processes, policies, and procedures, and then see where we are. Then implementation part. Then the client approval is required on the roadmap for GDPR compliance, and also the client needs to approve for the implementation cost as defined in the gap analysis report. And the final step is GDPR consultancy team implements the gap analysis report to help the organization become GDPR compliant. It's a very simple process, but when you start working on it, it becomes fairly complex and challenging for implementation because there are a number of factors to be considered, including the stakeholder management, the scope of work to be delivered on time at required quality from the GDPR compliance point of view, and within the budget also. Now I will explain to you more about what services we offer. We offer 4 different kinds of services. At GDPR Consultancy, we can take the full GDPR compliance project, starting from training to conducting gap analysis to delivering the compliance project. Or else, if the organization wants just the gap analysis, which in many instances we have experienced organizations do demand, we are more than happy to offer that service. Next is GDPR training, and this training will be at all the different levels within the organization, starting from the highest level at C level, right up to the operational level. And if the organizations are small, and that's our target market, then we can offer the retainership services as if we are acting on behalf of the client as the data protection officer, to help them with to deal with the situations of the breach and reporting that to the ICO, or also to conduct the periodic audits throughout the year. So these are in a nutshell 4 different kinds of services that we offer. And now we'll provide you with details of our contracts and the next steps. Thank you.
Thank you. Thank you.
Thank you.